Hi, my name is Letitia Anglin, and in this presentation, I will be examining two cases dealing with defamation. The first case is New York Times Company versus Sullivan. It basically deals with the freedom of the press. The parties involved in this dispute is the New York Times and L.B. Sullivan, who was the public safety commissioner in Alabama. Sullivan felt like his reputation was damaged by the publication New York Times put out because he felt that the false criticism of actions by the police was defamation of his character. It was his job to provide a service to the people of Alabama by making sure they were safe, and this publication actually painted a different picture. There are elements of defamation a plaintiff must follow. Because L.B. Sullivan was a public safety commissioner, he had to prove four things in this case. 1. He had to prove the defendant made false statements in regards to him. 2. He had to prove that the defendant made an unprivileged publication to a third party. 3. He had to prove that the publisher was negligent when publishing the communication. And 4. He had to prove special damages in the special case. In the end, the U.S. Supreme Court decided that news publications could not be held responsible for defamation to public officials unless the plaintiffs met the expectation of malice standard of the publication, which means Sullivan had to be able to prove false claims with admissible evidence. The second case is Gertz versus Welch. With this case, the U.S. Supreme Court issued First Amendment protection for private individuals who made defamation claims. The parties involved were Elmer Gertz and Robert Welch. The petitioner was in fact a private person because he generally did not engage in the public. It was alleged that there was a communist conspiracy that planned to run a dictatorship of the country. Another alleged statement claims that the officer had been framed at his criminal trial. He planned the officer's conviction while also participating in a communist organization, which is also another alleged accusation. It also states that Gertz had a criminal record and used the communist terms of abuse. The court denied the motion that Gertz knew and trusted that the author would make sure the facts were true, and therefore Gertz would only have to prove negligence. I think because Gertz was a private individual, it may have had dire consequences on his reputation. He did not intertwine much with the public, and unless the people looked at him as somewhat of a pillar in the community, there was no reason to not believe the allegations about him. If I were Robert, I would have tried to conduct an interview so that I could have asked the questions I wanted instead of assuming. My state is Georgia. The defamation law elements are a false statement about the plaintiff, communication of the statement to a third party in the absence of a special privilege to do so, fault of the defendant amounting at least to negligence, and harm to the plaintiff unless the statement amounts to per se defamation. For an example of that, you can see Smith versus Stewart. I learned one key essential thing with both of these cases: credibility. To avoid defamation, I feel like one must comply with the laws about not infringing on one's privacy and also be able to back up the claim as well. A solid defamation case must have credible evidence because in the end, it's about what you can prove. Going forward, I want to be sure to always follow the guidelines when writing pieces that I plan to promote to the public. Thank you for watching my presentation.